Hello, I'm Michael Lockley and welcome to session 4 of the Ladder of Discipline, where we'll be talking around formal notification to attend a disciplinary inquiry, as well as the rights of employees going into such a formal process. If you missed out on the first 3 sessions of this series, look out for the videos on my YouTube channel, Lockley Consulting. In the first session, we covered the 3 types of warnings that may be issued to employees as a means of corrective action, as well as addressing unwanted behaviour. In session 2, we looked at the process required to be followed to ensure that the issuing of warnings is fair, including the need for consultation. And finally, in session 3, we looked at the difference between negligence and misconduct-related charges. In session 4, we're going to cover the following 3 aspects: the actual formal notification to attend a disciplinary inquiry, the rules around suspension with pay prior to an inquiry, and then the right of employees within a formal disciplinary process. If we look at the formal notification to attend a disciplinary inquiry, this notice must be given in writing, and the minimum time given to prepare should be at least 2 working days. So if you're going to issue a notification on a Friday, you can't say, well, 48 hours later, Monday is the inquiry. That would be seen as inherently unfair. And how can they prepare with only a weekend prior to the inquiry? So the trend is to give working days, and also the trend is to give more than 2 days. So a minimum of 2 days would be given, and that gives you an out for giving longer time to prepare if the situation is more complex. For instance, consistent late coming might not be as complex as rolling cash from a debtor's point of view. The notification needs to fully outline in detail the charges against which the employee must prepare to defend themselves. If they don't know the charges and the details relating to those charges, how on earth can they be given a fair chance to prepare? And in most situations now, the CCMA specifically are finding that if you don't give your evidence up front, that's also inherently unfair. They have the right to look at what you're going to use against them. They don't have to know what your modus operandi is or who your witnesses are, or the sort of questions you're going to be asking your witnesses, but they do need to know what evidence that they have to prepare against. Otherwise, they're blindsided, and that could also be seen as inherently unfair. The notification should detail the time, the date, venue, and the name of the chairperson appointed to conduct the hearing. And the reason we recommend that the person's name is there is that one of the rights of an employee is to actually object to a chairperson, obviously on good grounds, and it's up to the company or the chairperson to decide whether there are fair grounds for the chairperson to recluse themselves and to find another chairperson. So it's always good that you do detail the name of the person who's going to actually hold the inquiry. All the employee's rights need to be outlined in detail, and we'll go through those in a separate slide shortly. Consequences of not attending the inquiry without good cause need to be stated as well. So if you can show that they have had time to prepare, they have received the notification, and for some reason they just don't pitch, obviously you err on reason and you'll probably give them one more chance, but it's trying to negate the fact that they can just simply not attend and believe that there are no consequences. So the consequences are that the chairperson may decide to continue in their absence. The form also needs to be signed as an acknowledgement of receipt, not an acknowledgement of guilt. And if they refuse to sign the notification, just get a reliable witness at a reasonable senior level to attest to the fact that they did in fact receive the notification. When it comes to suspension, it's always with pay prior to an inquiry, otherwise it's automatically unfair. And also, this is an area where a number of companies get it wrong. They automatically and unilaterally suspend an employee without consultation prior to an inquiry. Firstly, an inquiry doesn't have to lead to automatic suspension prior to that inquiry, and also you have to show you've consulted. You can't just walk up to the employee and say, there's your suspension, let it go. So all notifications for disciplinary inquiry do not necessarily lead to an automatic suspension. Suspension would depend on several factors, such as trust-related offences like theft, fraud, criminal-related offences, which are the same, assault as well, and concern around possible interference with evidence prior to the inquiry. There must be consultation prior to a suspension, and you need to make sure you can prove that there was a consultation. So for me, the pro forma suspension letter or the suspension letter you're given should detail the following: after consultation with the employee and after listening to and deciding on whether their reasons for not being suspended were valid or not, we have decided to suspend on full pay pending the disciplinary inquiry. You need to prove that, because an unfair suspension becomes an unfair labor practice, and you may have a dispute for an unfair dismissal, which is linked to an unfair labor practice, and that becomes complicated and not necessarily for this particular presentation. Always remember, therefore, consult and prove you've consulted prior to suspension. The rules relating to the suspension should be in writing. An example is being available at reasonable notice, as suspension is not leave or a time to disappear, not be contactable. They would ordinarily have been at work and they are being paid anyway. So the suspension letter needs to indicate that they need to be available should you need to consult with them. They need to be available to come to work during that suspension if required. They are still a bona fide employee subject to your rules and regulations, and within reason. You're not going to muck them around, but they need to understand that it's not a ticket to leave Joburg for Cape Town for a week, etc. And suspension prior to an inquiry is always with pay, not without pay. That would be an unfair practice, unless the employee themselves choose to accept no pay, and I can't see that ever happening. The rights of employees, and they are numerous in a formal disciplinary process. We need to ensure that procedural fairness is enacted or played out, and therefore the employer needs to accord the following rights to the employee, unless for some reason the employee chooses not to exercise some of these rights. And that has happened. Often an employee says they'll represent themselves. It's the right to be represented. They may not want to have a representative, or they can't find one. Another one is that they don't want a translator or an interpreter. They're quite comfortable to conduct the inquiry in the language in which the inquiry is going to be conducted. So those are just two rights that a lot of times employers actually forego. So the right to have the charges in writing, which we've gone through, sufficient time to prepare, which we've also gone through, the right to a representative, and your coach should make sure that that representative is a bona fide employee of the company. So they can't bring in mother, father, sister, brother, friend, lover, spouse. It has to be an employee. There are times when you may have to exercise your discretion, where there could be times where you want to allow, without creating a precedent, an outside representative. And again, that's detailed and not necessarily going to be covered in this particular presentation. The right to an interpreter or a translator, even someone who might be a Sotho speaker who's very proficient in English may elect, even though they're absolutely 100% comfortable in English, to have a Sotho translator or interpreter. You cannot deny them that right. Right to object the appointed chairperson, object to the appointed chairperson. Sometimes there could be a feeling of bias, or the chairperson being elected has had a run-in with the individual before. They have the right to object to the chairperson, but the company and the chairperson have the right to either accept or reject their objection. But then you need to be very objective as to why you are not falling for their objection. And if you are going to recluse yourself as chairperson, also give the reasons why, and give credit to the employee that they may have a case in terms of predetermined bias or whatever the case may be. They have the right to prepare and lead witnesses, and that's their responsibility. Witnesses should be prepared and they should be led, and they should be willing. No witness can be forced to come into a disciplinary inquiry against their own volition. The right to cross-examine evidence, the initiator and the employer witnesses, the initiator being the person who's preparing and leading the case on behalf of the employer. Employer witnesses also have the right to be cross-examined, and we'll look in the next session at the rules of cross-examination. The right to know the outcome as to whether they are guilty or not. A right to mitigate against sanction if they are found guilty. What are the factors that would sway the chairperson to not dismiss, to not give a final warning, etc., not demote. Right to know the sanction in writing. Right to appeal internally if there is such a procedure. A lot of companies are seeing that the CCMA has taken over the appeal process, so the trend is not to have appeal processes within the company for disciplinary issues. However, the trend is to keep appeal processes for grievance issues, and again, that's a different subject matter as well. So the right to understand the rights of dispute. They have the right to go and declare a dispute within 30 days for an unfair dismissal, etc. at the CCMA. And they should know those rights. We have nothing to hide if we've done the inquiry correctly from both a procedural and a substantive point of view. And procedure in terms of fairness and substance in terms of fairness is also a topic which will be covered in the next session. And they have the right to have the outcome and sanction in writing. They don't necessarily automatically have the right to the full set of minutes. That really is a cultural thing or a policy thing, depending on each company. But they do have the right to know what happened and what the sanction is and why. So in summary in this session, we've covered the fact that we need to ensure that notification to attend a formal disciplinary inquiry is given in writing. It details the charges, the date, time, venue, and chairperson, and detailing the rights that the employee has going into the process. We also have learned that not all formal notifications to attend a disciplinary inquiry lead to an automatic suspension prior to the inquiry. And prior to suspension with pay, a consultation process must take place. Otherwise, it could be seen as an unfair labour practice. Ensure all the rights of an employee are afforded to the employee unless the employee chooses to not exercise any of these rights. In session 5, we are going to cover the difference between procedural and substantive fairness, the concept of balance of probabilities versus beyond reasonable doubt, as well as the rules of cross-examination in a formal disciplinary inquiry. I thank you for the time you've taken to work through these slides with me. If you have any queries, you're welcome to contact me on locklearworldonline.co.za. It's on the slide. Please remember that the content in this video is not a legal opinion. Always consult a legal practitioner as needed.